Trump's civil rights have been so terribly victimized here. He is a crime victim, bar none. On the outrage side, you had the appellate court here in the District of Columbia rush through in a hysterical opinion by anti-Trump judges that upheld Judge Chutkan's lower court opinion. This is what I said on Twitter about it. Anti-Trump, well, this is something later. I've carefully reviewed D.C. Circuit opinion upholding Judge Chutkan's extremist decision to undo our constitutional system of government by allowing the unprecedented prosecution of Trump for official acts as president. The Rush decision is another nakedly political act that seems primarily designed to ensure that Joe Biden's appointees can jail his political opponent before the election. The Supreme Court can't undo this judicial assault on the rule of law soon enough. Our republic's at stake. And, to further prove the political nature of this whole process, the D.C. appellate court rushed through and kind of forced Trump to speed up any appeal he wanted to have. Typically, ordinarily, according to the rule, and this is what I talk about later, you can throw up this tweet now, they sped up the mandate issuance to allow Chutkan's trial to proceed against Trump from the ordinary 52 days to less than a week. Now, what do I mean by mandate? Now, this is where, I'm not a lawyer, and so it means I don't practice before the Federal Court of Appeals. But my understanding of a mandate is when an appeal is, an opinion in a case is issued, and a mandate issues from the appellate court allowing the lower court to get back on the case and continue to proceed as the appellate court opinion directed. But because sometimes the litigants object, there's a delay in the issuance of that mandate, which can be as long as 52 days ordinarily. Instead, they rushed it to less than a week. So I don't know if the Supreme Court's going to take this up. I don't know if Trump is going to ask the full court to take it up, the full appellate court, the en banc, ask for an en banc review. But you can see they're desperate to try to get him jailed, and you can be sure that given this decision by her to not prosecute Biden while condemning Biden essentially for being incompetent because of mental challenges and memory challenges, they're going to be in a desperate state to rush this prosecution of Trump. So they get their little victory with the anti-Trump judges here in the District of Columbia. But also it looks like they're angry again because the Supreme Court of the United States wasn't terribly interested in turning America into a complete one-party state and seems to suggest that there actually has to be an election in 2024 that's legitimate, meaning that the Supreme Court justices had a hearing on Colorado's efforts to throw Trump off the ballot and the efforts generally of the left to throw Trump off the ballot based on a malicious and bad faith reading of the 14th Amendment to justify, as I say, turning America into a one-party state, A, by falsely accusing him of insurrection. This is the clause that's relevant here. Section 3 of the 14th Amendment. No person shall be a senator or representative in Congress or elector of the president and vice president or hold any office, civil or military, under the United States or under any state who has previously taken an oath as a member of Congress or was an officer of the United States or as a member of any state legislature or as an executive judicial officer of any state to support the Constitution of the United States shall have engaged in insurrection or rebellion. Do you notice what's not there? President. No person shall be president. It doesn't say that. And of course, Trump didn't engage in insurrection. So that's malarkey. We filed a case, an amicus in that case, a big hearing before the Supreme Court, and it looks like it's going to go bad for the left. We have a sample of some of the questioning between not only the conservative justices, but the left-wing justices. Let's go to that.
When you look at Section 3, the term insurrection jumps out. And the questions are, what does that mean? How do you define it? who decides? Who decides whether someone engaged in it? What processes, as Justice Barrett alluded to, what processes are appropriate for figuring out whether someone did engage in that? And that's all of what Chief Justice Chase focused on a year after the 14th Amendment to say, these are difficult questions, and you look right at Section 5 of the 14th Amendment, as the Chief Justice said, and that tells you Congress has the primary role here. I think what's different is the processes, the definition, who decides questions really jump out at you when you look at Section 3. Your response to that?
Well, certainly, Justice Kavanaugh, there has to be some process for determining those questions. And then the question becomes, does anything in the 14th Amendment say that only Congress can create that process? And Section 5 very clearly is not an exclusive provision. It says Congress shall have power.
But maybe put most boldly, I think that the question that you have to confront is why a single state should decide who gets to be president of the United States. In other words, this question of whether a former president is disqualified for insurrection to be president again is, just say it. It sounds awfully national to me. So whatever means there are to enforce it would suggest that they have to be federal, national means. Why does, if you weren't from Colorado and you were from Wisconsin or you were from Michigan, and it really, what the Michigan Secretary of State did is going to make the difference between, whether candidate A is elected or candidate B is elected. I mean, that seems quite extraordinary, doesn't it?
The more broad point I want to make is that what is very clear from the history is that the framers were concerned about charismatic rebels who might rise through the ranks up to and including the presidency of the United States.
But then why didn't they put the word president in the very enumerated list in Section 3? The thing that really is troubling to me is I totally understand your argument, but they were listing people that were barred, and president is not there. And so I guess that just makes me worry that maybe they weren't focusing on the president and, for example, the fact that electors of vice president and president are there suggests that really what they thought was if we're worried about the charismatic person, we're going to bar insurrectionist electors, and therefore that person is never going to rise.
So you can see you had the two liberals, Elena Kagan and Ketanji Brown Jackson, the most recent Biden appointee, significantly question this effort to remove Trump from the ballot. It looks to me, excuse me, like it may be a 9-0 vote. Maybe it'd probably be an 8-1 vote. Sotomayor, who knows where she is on these issues. It wouldn't surprise me if it was a 9-0 vote. And sometimes these judges issue concurring opinions, which is an opinion not joining the majority, but kind of saying I agree with the result for different reasons or with certain caveats, which would be a big victory for the rule of law and clean and fair elections, and a big blow against the left's efforts to destroy our system of government. The fact that they're undertaking this, and even if they lose, I think it's a problem because they've gotten so far, because it's so disruptive to the rule of law and if you're running for office and if you're wanting to volunteer, I mean, you should be spending your time on electioneering, right? Campaigning. And when the government and government officials abuse their powers to stop you from doing that with these ridiculous ideas that you can be removed from the ballot, something out of, Putin's Russia. That's election interference. Whether or not you end up winning in the end, you've been derailed, distracted. I tell you, as I said earlier, Trump's civil rights have been so terribly victimized here. He is a crime victim, bar none, in terms of the history of the United States, in terms of political crimes and crimes by the government targeting him. It's just unbelievable. And I'm glad the Supreme Court is going to shut this down, by all accounts. And I just hope it gets to be 9-0, because that's what it deserves. They should say no, 9-0, to this effort to destroy our republic and rig the elections. As I said, we have an amicus brief. You can look it up at judicialwatch.org, which explains our view on it as well. Thanks for watching. Don't forget to hit that subscribe button and like our video down below.